was given time served. However, the sentencing had to be adjourned and reset because the state didn't have the complaining witness for the victim impact statement. But he was given time served and a PR bond to go to the AFC home. Just your honor, as to allocution, you're very well aware of the longstanding of this case. I would just ask if there's any way to get rid of the mandatory $175 fines, costs, and fees. So
I'm
we
just
don't
giving them
hold Mr. Terry's.
312 days, credit for 312 days. And let circuit court then handle any other matters.
Yeah, and there should be no other matters. Your Honor.
All right.
Thank
Good luck,
you.
Mr. Ferris.
He'll be transferred tomorrow.
All right. Take care. In the matter of People versus Richardson on file number 241927. Appearances, Ms. Richardson can come up. Appearances for the record.
May it please the court, your honor, Robert Hamburger, retained counsel on behalf of Autumn Richardson. I'm a special assistant. I'm a former special assistant attorney general. My bar number is P14570.
Are there any additions, subtractions, or deletions?
No, your honor.
Anything else by way of allocution?
Your honor, I would just like to indicate that my client has pled guilty and she's currently working at McDonald's, although she's scheduled to begin work as a caregiver. This was her first offense and she's working on her GED.
Did she enter into any counseling? Where is she at? Well, I read where she's in medication, but is she in counseling currently? Are you in counseling presently?
Not yet. I would want to go through there with my Medicaid. I just have to get new Medicaid cards and stuff like that, so I wasn't able to yet beforehand.
Let me do this. So you're working?
Yes.
How long have you been there?
At this McDonald's, I've been there less than a year, but the previous one I was there for 4 years.
Is there anything else that you want to say on behalf of your client?
No, your honor, it's just that I believe that the prosecution has agreed to SoberLink and AA classes and 9 months probation.
I noticed that the probation wasn't on there, but part of that may have been I wasn't quite sure whether I wanted to do probation. However, given the situation, the facts surrounding the case, let me just go to where my notes are. I'm gonna do this. So what I'm going to do is add, I had 9 months supervised probation. With, so that's the only thing I'm going to add with random and refrain. I am going to take the fines down a little bit to offset some of that cost. And then substance abuse counseling. You must enroll with that and show proof that you've enrolled within 5 days of today's date. All right. And it can be its equivalent. If it's not CST, it'll have to be someone that is approved by the probation department, okay? There are also random and refrains, and Ms. Lyons will go over that. with you. You're a very lucky person to be here, and your children to actually be alive based on your actions of that night. I don't think that I have to kind of reiterate or belabor the point. You've probably done that yourself. My concern is whether or not you're able to maintain a path of recovery. Okay, good luck with everything. Thank you, sir. Have a good day.
Thank you, Your Honor. In the matter of People versus Reduce on 243684.
Yeah, Robert.
Oh,
Yeah, yeah.
all right. Any additions, subtractions, or deletions?
So, yeah.
All right. Anything else by way of elocution?
Nothing.
All right. So I know, Mr. Ledoux said it's not on there with regard to the probation, but I'm gonna add that. And, I don't have a problem in reducing that once everything goes on. But, given I know what you're going through, and I think that it's rather important. So, the only thing that I will add is the 6 month supervised probation. I'm gonna drop the sober link down a little bit. I know the fines were agreed to, so I won't really touch on that.
Right.
I'm gonna strike number 8. And then CST or its equivalent, so, and then time to pay as well, we'll start with 60 days, as we know.
Thank you.
Good luck.
Thank you.
Mr. Tatum, are
Ready, Judge.
you, People versus Huggard on 235474.
Good afternoon again, Your Honor. Trevor Tate on behalf of Mr. Hogan, who's present in the courtroom, standing to my left.
Are there any additions, subtractions, or deletions?
Just one correction at this point, Judge. The report does indicate under pending charges, a Bay County case from 2021 and a Midland County case from 2022. Relative to the Bay County case, Judge, my understanding that case was dismissed after speaking with Mr. Huggard. The Midland County 22 case, he was sentenced to fines, costs, and fees in that.
If you're drug tested today, how would he test?
Judge, he indicates that he will be clean. If I take a segue to go into allocution, Judge, it's my understanding after sentencing that Mr. Huggard did enter inpatient treatment at Sacred Heart. He indicated that he only stayed just shy of a week. That was all that he could afford. But he further indicates that he has been attending recovery pathways weekly, seeing a therapist by the first name of Kaylee. He couldn't pronounce the last name. He does indicate that he is on Suboxone through recovery pathways. We did have a conversation, Judge, within the last hour where I certainly emphasized that he needed to be forthcoming if he would be positive for any substances. He was adamant that if he was tested today, he would be clean.
He was instructed to bring proof of his counseling.
Appointment card in my wallet for this week. 10/16/24 with Haley. Oh, my bad. And her number is. Sorry about the judge, I wasn't aware.
So how are you gonna afford all these fines and fees for your lockdown?
I'm currently looking for a job, Your Honor.
And Judge, I did want to address that at the court.
Yeah, please go ahead.
Judge, I apologize. I briefly went into allocution.
Yeah, I'm
relative
sorry.
Specific to the,
I kind of took you off the order by asking the question.
briefly done. But Judge, looking at the recommendation, I believe when we entered a plea agreement in this matter, there was a recommendation by the prosecutor's office of fines, costs, and fees only. Given that this was what I understood to be an isolated event of retail fraud that are specific to this target. There was a bottle of cologne, I recall, at issue, which was recovered, so there was no restitution. When I look at the recommendation, Judge, the 90 days of GPS tether, he is unemployed. The agent has recommended the maximum fines and costs in this case, or the alternative being 93 days. And I would offer to the court, Judge, understanding that there is not a term of probation that's been recommended, no return of incarceration. It does seem that 90 days on GPS program with a curfew would, in some respects, although it's not actual incarceration, essentially serve to be the same effect. So I was preparing to ask the court to modify the GPS program consistent with the plea agreement, Judge.
What happened with his probation in Bay County when he was sentenced?
It's my understanding, Judge, he's still on probation for that case. He hasn't been released.
Is it because he's violated the terms of his probation, or have there been any violations while on probation?
None that have been brought to my awareness.
So I understand that he's on probation, but then he comes down here and he steals.
I didn't bring his file, Judge, but have just a brief moment.
Yeah,
I don't recall the incident of this particular offense of 12/7/23. So it could technically be a.
outside of the probation period.
It could have been, Judge. And I believe he had several matters going on, Judge. I believe I represented him previously on another matter. This is the last of any outstanding matters. Hopefully that will keep him out of the court system at this point in time.
What's the substance you were on?
I was addicted to heroin for like 3 years, but I've been in treatment for the past 2.5.
Then why would you, within that time period, go and steal?
I was having money issues, and it's not a good excuse. I apologize for my actions. I don't intend on ever bringing myself in that position again, Your Honor.
Well, you have an open case, as well?
No, no.
Oh, I thought there was a pending found over circuit court on forgery.
Mr. Tatum just explained that one to us, Your Honor. He said that case in Bay County was dismissed.
Oh, I'm sorry. I apologize. I'm still focused on the 18 months narcotic probation period up in Bay City as well. I would rather have a drug screen before I'm gonna do this. I'm gonna adjourn, reset, drug screen before, and then we'll adjourn it out for 2 weeks. You on day reporting? I don't think you were you?
No, Your Honor.
No, I don't have any screens whatsoever. Apologize but I'm I don't have a problem in avoiding the GPS. To be quite honest, I was just gonna give him the 30 days in jail, given his prior record. But given what your allocution of wait and see, and then maybe we'll change some things.
I appreciate that, Judge, and that'll give me some additional time to get with the therapist and sort this.
All right, thank you. Yeah, if I get that. You signed all
Tested today,
What's that?
tested today.
They'll direct them where to go for testing. And then, you've signed all releases. I don't want us to have to call over and find out your therapist isn't gonna release because you didn't allow it.
I will make sure it's done. I'll
We'll
take
talk
it.
about that, yeah.
In the matter of People versus Mackey on 235554,
Good afternoon, Your Honor. Alan Crawford, appearing on behalf of Mr. Mackey.
hello, Mr. Crawford, good afternoon. Are there any additions, subtractions, or deletions?
No, Your Honor, the report is accurate.
Anything else by way of elocution?
Yes, Your Honor. My client would like to apologize to this court. We understand that there was some miscommunication the last time he was here in regards to his PSI interview. He was instructed by his prior counsel not to make any statements about the actual offense because he had a pending case. Well, he still has a pending case. And my client just merely took that too far. He didn't understand what he could and what he couldn't do. And because of that, that's the basis for the miscommunication, Your Honor. So we do apologize for that. As it pertains to the offense, this is outside of my client's demonstrated character in the past. I feel that his emotions have gotten the best of him in this matter. He's dealing with a toxic relationship and should have just merely walked away. He's definitely embarrassed by what he did. He has agreed to pay the restitution and he simply just wants to move on from this. I would note he has been on tether for this case since June. And
Yeah, he owes $1,000.
we do feel that the recommendation is appropriate. Would ask the court to follow that.
What is there, when I look through the case that involves strangulation upstairs, it's my understanding that there is a plea deal in that case. What are the terms of that plea deal?
Your Honor, I believe the plea deal was they dropped it down to a felonious assault. But right now, we're not inclined to take that. We were in front of Judge Morello yesterday. We are rejecting that offer.
So it wasn't a plea deal then agreed upon by the parties, or it was just set for a plea to consider?
Yeah, they just set it for a plea. We didn't schedule that.
Okay. And that next court date is on November 4th.
That is correct, Your Honor.
That case has been hanging for a minute, as has this one.
Yes, Your Honor. I just subbed in on both of his cases. It's my hope to resolve the other one, but right now we are far apart for resolution and we might need a trial on that case, Your Honor.
Here's my concern. So he was charged the end of December. No contact was put in place in March. It's my understanding that when I read through that no contact has been ignored. There's also the case that's pending upstairs involving the same victim. Had a chance to review the impacts of the impact statement. So if I am to get his version of the events, he denied, or he said that on advice of counsel, he wasn't gonna answer any questions, which then says I go by the police report and any other information that has come to my attention. So is there a reason why I shouldn't just sentence him to the maximum on this based on the nature of the charges and the abuse and the terror that he has embarked on an intimate partner?
But Your Honor, in this matter, he's been charged, he's pled guilty to malicious destruction of property, less than $200. The more serious offense, the great bodily harm, domestic violence, my client strongly maintains his innocence. The prosecution has offered him a plea to a felony. He's rejected that. He feels that he has done nothing wrong.
But I have nothing to indicate his version of the events on that night, so all I know is that, yes, he did plead, but there's his terroristic actions towards his intimate partner at the time are of concern to this court. So, I mean, I am not, why I don't get involved in the plea deals, I am not happy with this plea deal. I don't doubt anything that I have read from the victim. Now, let me go to what I also have. It's my understanding that there was a probation violation on the case that he's in upstairs. Judge Jones amended that probation violation, that he should have pretrial treatment through CST counseling. I spoke with Ms. Joseph today regarding whether or not he completed that. It was my understanding, while it was just a little outside the time, that he did complete that. Is your client still employed?
Yes, Your Honor. He's working at Next Year.
You were retained after he made his statement to probation?
Yes, Your Honor.
I think what I will do is adjourn so I can get the defendant's version. And then,
Yeah, the victim is here, she would like to speak.
if he wants to. I'm not gonna sentence him today. Does she still want to? I don't, fine if you want to.
Your Honor, she says she'll wait for sentencing.
That's fine.
Okay.
The only thing I would caution, he has $1,000 on GPS that he owes. If he's gainfully employed, why has he not taken care of his debts?
I will ensure that he gets on top of that, Your Honor.
Thank you.
All right, thank you.
In the matter of People versus Boyke, on file number 241279. Appearances for the record.
Good afternoon, Your Honor. Aubrey Smith on behalf of Ms. Boyke. Before I begin, Your Honor, she is undergoing treatment for her stomach cancer and she's not feeling well. Do you mind if she says this?
Oh, I don't, that's fine.
Yes, please. Your Honor, we have reviewed the report. We just have one slight correction. And that's to her employment, Your Honor, since being diagnosed, she's no longer working as a home healthcare aide. She's currently unemployed. Other than that, the report is.
And for elocution.
Your Honor, I believe the recommendations are appropriate in this case. Ms. Boyke does take responsibility for her actions throughout her interactions at Meyer. She does understand the gravity of what she was facing and the gravity of what she did. She has no problems paying back the money that she owes to Meyer. I just would like to highlight from the board that this was an ongoing situation where she did feel as though if she was not doing these things, that she would be punished for not doing them at home. She has since left that abusive relationship, and in all ways but her health is doing much better. She has been recently diagnosed, as noted in the PSI, with stomach cancer. She just started her treatments for that. And although she's unemployed, she's going to get help with her financing costs from her son who lives in North Carolina.
What was the facts and circumstances surrounding her 22 case that involved stealing?
Your Honor, it's always very similar. She was working at two different places, at Speedway and at Meyer at the same exact time. I believe the 22 case was from Speedway, and this was from Meyer. It just unfortunately fell through the cracks for not getting arraigned at the same time and going through the process at the same time. But I believe that she was offered a blatant dismissal in that case as well for the same reason. And yeah, but she did pay her fines and costs, as she just indicated, and it's all been squared away since then.
So why was she with him since 12? Your maiden name was Hendrick? What was your maiden name?
LaBelle.
And left right there.
You were never known by the last name of Hendrich? Okay. There was another case, another domestic violence case with Mr. Boyke, is that right? That you had?
I had a domestic vehicle.
What happened to that?
I was scared and I left.
I can't hear you.
Your Honor, I believe that we discussed it. So you didn't show up to work for that, correct?
I was here and then I had left because I was going to help him and I.
So Your Honor, she chose not to move forward with charges. She was afraid of the repercussions that
I
it may have brought.
hit him with 60 places.
And after she did not move forward with charges, she has indicated that that is at that point when she moved into her sister's basement, and left her children in another location to kind of hide from that situation.
We also have civil cases with Frankenmuth Credit Union and there's another credit union.
Yeah, I spoke with them on the phone already. I don't know anything about my taxes.
I'm just trying to understand your thought process on you only had one other case that was filed against Thomas Boyke. Or will adopt the recommendation. Time to pay, we'll start with 60 days, set up a payment plan. All right. Anything else? Oh. Hold on, Ms. Blakey. County Jail, or Leland, sorry. We have Leland County Jail coming in on Monday?
Yeah, Yanak.
Oh, yeah, oh, that's right, we're waiting for Mr. Kanishevsky.
Oh, is he taking that?
I believe so.
Okay.
He had contacted us to see if he could zoom in. So we'll wait for him. Is there a David, we're waiting for Mr. Brown, David Brown?
He's gonna be a couple minutes late.
Oh.
He should be on by now, though.
Is he appearing by Zoom?
They didn't say that, they just said he was gonna be a couple minutes late.
Okay,
He shouldn't be.
all right.
Is he on Zoom?
No, just Leland on. Are you ready on the, or we're waiting for a prosecutor on the violations?
I don't think we need a prosecutor. Neither one of us are hearing.
Okay.
Right.
Let's start with Parks. In the matter of People versus Parks, 4322393, you have any Parks, Ms. Parks?
We do not, Judge. We're a few minutes early,
All right.
so.
Who do we have? Oh,
Krensky and Davis.
all right, let's start with Davis. In the matter of People versus Davis, 222948.
Good afternoon, Your Honor. Zachary answer on behalf of Ms. Davis, present in the courtroom today. Judge, this is a date and time set for a show cause. I've gone over the alleged violations with Ms. Davis. I don't know, would you dispute some of them? She claims that she did pay the $180. As to the second paragraph, Ms. Davis indicated to me that she was participating in the Color Code program. Her recollection was that around July, you went into labor and delivered. And that it was her understanding, I don't necessarily, can't speak to why, but it was her understanding at that time that she no longer needed to participate. Go ahead,
Mr. Coltrane said I was done with it.
prior counsel.
That was my,
So Judge, obviously I can't speak to that, however, I don't think she was intentionally trying to not comply, it sounds like she was complying prior to going into delivery.
I got the receipt for the 180 hours. I paid that.
Yeah, no, I got it there.
From last time, yeah.
Yeah. Yeah, I think it's in between
I
the
didn't
five.
know about the classes that Joe was talking about.
Well, why wouldn't you?
Mr. Coltrane said I only had to do the tether and the color code, and that's what I was doing. I didn't know about the classes. If I did, I would have did them.
Well, what I told you, back on, 10/8, no, not 10/8, back on.
Yeah, she was sentenced on March 6th of 23,
Yeah,
and she signed a probation order, term number 11, said that she would enter in complete counseling with the community mental health.
Is that the one I'm doing now with Mr.
well, here's my concern, you know, I saw you back in 22, right?
Yeah.
Yeah, we had to go through the same process with you. I think that was the one in 22, no, it might be this case. You saw, I forget who, back in 23, you had that larceny. I saw you a couple of times. Then you were down in Genesee. What happened with all those cases?
I was supposed to go up there Monday, but I couldn't because I had to come here. Cause I told them when I went up there, when me and my mom went up there, they didn't act like they didn't know what I was talking about.
Yeah.
Cause that had happened at the skating rink and
Are you still over on Amherst?
no, yes, I am. I am,
Oh.
yes, cause I had to move from Genesee. Yeah.
Is that your mom's place?
Yeah.
All right, how long you been in jail?
5 days now. I got 18 days left.
On your other sentence?
Judge, it's my understanding that Judge Stern sentenced her to 30 days.
All right. 30 days, credit 30 days, discharge without improvement. If there was a probationary period.
Thank you, Judge.
In the matter of. In the matter of-
Shoot something, I'm sorry.
Oh, that's all right. In the matter of People versus Krensky, or is it? Okay, on 224207.
Thank you, Your Honor. Zachary Answer on behalf of Ms. Prensky. Judge, I was hoping to speak with you and Ms. Slaughter privately in chambers before we address this on the record.
We do this, I'll recall the case in a minute. Let me get through two other matters.
Thank you.
And we'll leave it off. All right, in the matter of People versus Yonak on 20410, appearances for the record.
Afternoon, Your Honor. Adam Kanishevsky on behalf of Ms. Yonak, who's appearing via Zoom from the Leelanau County Jail.
And today is the a petition on the show cause.
Accurate, Your Honor. She was supposed to get hooked up on a SoberLink unit where the court had given her 62 days on SoberLink with 2 days credit. She failed to do so. She'll acknowledge that she did fail to do so. I provided the court with a judgment of sentence. She was just sentenced about a week ago to 90 days jail on an OWI third up in Leelanau County. So she's 7 days into a 90-day sentence. I would ask that the court let her acknowledge the fact that she did not get set up on the SoberLink unit. Give her credit for time served. I believe this was a 93-day max with 2 days credit. And just let her serve her time up there.
All right. So, 93 days, and then it shall run concurrent. So it will result in credit. And this is on a 93-day max sentence on the original chart, or on the charge. So nothing else this court will have. And the fact that she's up north, so they leave it to the rest of the court up there to handle. Anything else?
The court would also give her work release consistent with what's going on in Leelanau County. I don't know if it would affect her if she's just given the time down here as well, but I assume you're okay with her getting out and working.
Yeah, everything would be concurrent. So I don't have a problem.
Okay.
All right. Thank you. Good luck, Ms. Yonak.
Thank you, Your Honor.
In the matter of People versus Fisher, 243100. Appearances for the record.
Connor David Conner.
Any additions, subtractions, deletions?
Your Honor, I believe that the pre-sentence investigation report is factually accurate. There was the issue that we had still remaining outstanding, that was restitution. If we could not reach an amount, that the matter would be scheduled for a hearing regarding restitution. We have not reached an amount, so that would need to be handled after the fact.
Okay. I know I did. I know
I don't know what I need to do from here, but I was wondering if I could call my attorney again to make sure he has that information.
Ms. Yonak, I'm just gonna.
Oh.
Remove her from the Zoom. Thank you, Leelanau. The attorney's already
Thank
signed up. So you have to give Mr. Kanaszewski a call, Ms. Yonak.
Thank you, Your Honor.
Thank you, Leelanau County.
You're welcome. Thank you, sir.
All right. Sorry about that, Mr. Durham. Yeah, I wondered about with regard to the restitution. When I was looking through the statements made by the company's representative. Anything else by way of elocution?
Your Honor, I believe that the recommendation is fair under the circumstance. I believe my client, under the alternative that they had presented, would prefer numbers 1 through 6 rather than number 7, which was presented in the alternative fashion of having the fines and costs. The court can take the notice of the lack of any record for my client in terms of sentencing for him. I think this is an appropriate sentence for the fines and costs, Your Honor.
Yeah. I was a little concerned, though. It seems like he certainly tried to put himself in a favorable light with his interview with probation. He just said it was for some fuel and cigarettes. Looked at the video. There was an accounting which we'll get into, I'm sure, at the restitution hearing. And I did, I was going to ask him to write a letter of apology, but I did read his text message to the owner. I thought the owner basically summed it up pretty good. The owner says there was about 17,000. I know we'll get into that in the restitution hearing, but that's a little more than just cigarettes and gas. You said also that it was used gas for the plow or to pick and drop off parts. So again, I know we'll get into the restitution, but it goes more than to what your statements were. So that's my only concern. I don't doubt you feel lower than a snake's belly, because that's about where you are in dealing with the person that trusted you. But as your attorney said, there's no prior record. I was just trying to figure out why you were doing that. When you were put in a place of trust with someone that obviously gave you a lot of trust. So let's do this. 3 month supervised probation. Give me an idea of where we're at. $150 fines and costs. Number 2, strike that. Duplication. 75 and 50 are state fees. 50, 30 per month oversight. CST, the theft offenders program. Random and refrains, as will be explained. Again, that'll give me some indication of where everything's at. Restitution hearing. And alternative 93. Did he do 3 days in jail? Was there? He didn't do any time in jail, did you, Mr. Fisher? I didn't think so. So alternative 93. Time to pay, we'll start with 60 days. Set up a payment plan. I think the 3 months on probation will give me an idea of what's going on. But the restitution hearing will schedule, Mr. Brown, or will be scheduled by the prosecution.
That's right.
And go through that. Thank you so much. Good luck,
Thank you.
Mr. Fisher. Abigail Parks? No Abigail Parks. That's on file number 4322393.
Good afternoon, Your Honor. Zachary answer on behalf of Ms. Parks. Ms. Parks is not here to be present this morning. Judge, I checked the hall for this afternoon. I checked the hallway. She was not present. I did leave a voicemail yesterday at a number ending in 1750.
All right, defendant having failed to appear. A bench warrant. $300 cash only. This is her, at least her second failure to appear. All right, thank you. I understand that there's some other matters dealing with her kids. Thank you.
Thank you.
All right.
Yes, Adams,
Tony Mason.
so is Johnny V.
What's that? Oh, wait. Yeah, sure. The know was pretty bright and, it was. So it may have been. Yeah, this morning was a nice settle day.
Years, so,
Oh,
yeah, a long come afternoon.
Still. Five.
Are they about ready?
I asked him. Right.
Matter of People versus Krensky on 224207, appearances for the record.
Good afternoon, Your Honor. Zachary Answer on behalf of Maya Prensky, present in the courtroom this afternoon. Judge, this is the date and time for arraignment on probation violations, 4 paragraphs. Judge,
Reading on the violations.
no, Judge, we would, Ms. Krensky is prepared to acknowledge all 4 violations. I do, Judge, if I could just make a brief record.
Yes.
In consultation with Ms. Romo from my office, we had prepared what we thought would be some appropriate actions the court could take this afternoon. In chambers, those recommendations were reviewed with Your Honor. It's my understanding that they are not at this time going to be accepted by the court. We would then ask that sentencing be set for a different date so that an updated PSI can occur. Ms. Krensky's mother is in the courtroom this afternoon. I just wanted to note that in case that you want to speak with her in regards to housing options in the future. And other than that, like I said, Judge, Ms. Krensky would acknowledge the 4 violations and we would ask the sentencing be set.
So let me just go through, Ms. Krensky, I wish to acknowledge I'm not so much worried about number 1. However, you did fail to submit to drug testing in October of last year, all the way through November, in December at the health department. That is correct?
Sir.
You also failed to attend and complete treatment through Great Lakes Bay Health. Is that correct? And then you also tested positive for methamphetamines and cocaine during the term of your probation, more specifically last year, correct? All right. So I also, I want to give you a reason why, of course, and I'm not yet ready to. It's my understanding that circumstances have changed, where that any use of substances is going to be detrimental to the position that you're in now. That is the reason why I am hesitant to do anything that releases you from jail. Going back to on or about let's see, June of last year, there was another hearing that we were setting, and I had to refer you over to Valley OB. Number of violations were noted at that time as well. You also disappeared for a period of time. So what I will do is accept the plea as to the violations. refer for an updated pre-sentence report. I don't have a problem in addressing this issue, which it is, as a health issue. However, it's not just your health at this point that I am concerned about. And if I have to leave you in there for the next 9 months, I will have no problem doing that. So, but I will give an updated pre-sentence so I can, we can address these issues, and if there's some alternative that affects or that we can address the health dynamic, then we'll do it at that time. Anything further?
Briefly, Judge.
Yep.
I just curious because I was hiding from the schools using.
It is done what is done. The fact remains that you still test positive, you don't test, you don't follow with what I do. And now there is another life for which that I am concerned about. And I will not release you. Anything else, Mr. Yancey?
No, thank you.
Very well.